Hi, everybody. Welcome to another pre-class set of slides. Today, you were reading about some issues that have to do with notifying if you don't have to notify. So a few points on that. Remember that data breach notice obligations are triggered under the data breach notification laws if, as we've talked about, there was personal information as defined by relevant law, which I also call triggering information. So information that if breached would trigger a duty to notify. And the fact pattern constituted a breach. So a breach is defined by the relevant law. Remember, there's access, acquisition, access or acquisition, both, etc., and that no exception existed. So encryption, no likelihood of harm, those kinds of things. So what happens and what do you do if the situation or the fact pattern isn't a breach? So there are risks under deceptive trade practices laws, which you read about. And there's also issues around if you determine that there is no duty to notify, what steps you have to take even if you don't notify. And we'll look at both of those in a moment. But one last point, which often comes up in this space, is how do you treat people who are in jurisdictions where a breach doesn't exist? So a breach might exist under 15 of the 25 impacted states. What do you do about folks that are in those remaining 5 states? And generally, you want to treat them the same way you treated everybody else to avoid allegations of unfairness. You told these other people in those 15 states, but you didn't tell the people in those 5 states. So that's something to think about. Let's look at these other 2 issues in a little more detail. So first, under the Unfair and Deceptive Trade Practices laws, often referred to as UDAP, Unfair Deceptive Acts and Actions, Activities and Practices, under these laws, and this is covered in chapters 5.2 and 5.8, we have issues or risks under allegations of unfairness. We were fundamentally unfair because we didn't tell people information that they could have used to protect themselves. That's one factor. Another is that there is some lack of clarity under the definitions of personal information and breach, especially as it applies to different fact patterns, as you've been seeing from our reading and applying the laws to the different breach scenarios that you guys have been playing around with in class. So in those situations, you might want to err on the side of notification to protect the individual, with the caveat that we have been thinking about throughout this class of, does notification really protect an individual? And then another thing to think about is, what does the regulator expect? And typically the regulator is going to expect that you are going to communicate with people, and that communication might be a regulatory expectation, but again, it goes back to, in this circle, does that really help people? But these are the situations where we think about notifying, even if we don't have an obligation under the breach notification laws, and something that we will often weigh when we are making our decision, and something that you're going to play around with in class. We're going to look at a couple different fact patterns to play with this analysis. Another part of what we're thinking about is, just because we don't have a duty to notify doesn't mean, under the breach notification laws, and by notification, I'm talking about notifying impacted individuals, it doesn't mean that all bets are off and we have nothing we're supposed to do. Usually the notification, the lack of a duty to notify, is going to happen because harm isn't likely. It could be because there's no triggering information, therefore the breach notice law doesn't even come into play, but often there isn't a duty. We might determine there's no duty to notify because harm isn't likely. In that situation, in 3 states, we have to notify the AG. New York is if we meet a certain threshold. So if there's 500 impacted individuals. And in Florida, we have to notify the Department of Legal Affairs that we've made this determination not to notify. In many other states, we have to have internal documentation about this decision that we've made and keep that documentation for either 3 or 5 years. So one other factor to consider as you're going through the reading is who else might you have to tell about this situation, even if the notification obligations aren't triggered. And when I say tell or share, I'm not talking about notification, which is a legal obligation under the breach notice laws, but instead I'm saying where might we have to tell someone or share with them that this situation is going on. And one situation, the one that comes up most frequently, is our insurance carrier if we have insurance to cover the costs of a breach. At the stage when it's still an incident and we're still trying to figure out what's going on, we need to let our insurance carrier know so that they can cover us under our policy. Another situation that comes up a lot is telling a client. There may be contractual obligations. If we house information, we may have obligations to share the fact that there's a potential incident with our client. And we might also have legal obligations to tell the client, which is talked about more in Chapter 647. Finally, another scenario that comes up a lot is if there's credit card numbers involved. If we're the merchant, for example, and there is a breach of credit card numbers, we may have an obligation to involve or share with the credit card schemes, meaning the credit card companies, so MasterCard, Visa, Discover, etc. So those are things to think about as you're going through the reading. And as always, I hope this was helpful, and I will see you in class.